Hello, everyone. Hello, everyone. I'm Tracy O'Brien, co-leader of the OFCCP Compliance Practice Team and a member of the firm's Labor and Employment Practice Group. Welcome to today's webinar. Before we begin, I would like to cover a few housekeeping items. At the top of your audience console, there are multiple application buttons for your use during the program today. If you have any questions during the webcast, please submit your questions in the question box. We will try to answer your questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later after the event via email. A PDF of the presentation is also available. It is in the program material folder. This program has been approved for legal education hours for live attendees. Report your hours by clicking on the Continuing Education Sign-In button at the top of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and for sharing. Toward the end of the program, be sure to complete our short survey. We appreciate your feedback, and we use your feedback to plan future programs that are applicable to your business needs. That ends the housekeeping items for today, and we will start our program. Joining me today is Wendy Ahrens. Wendy navigates complex antitrust and competition issues that arise during mergers, acquisitions, and collaborations between competitors in a variety of industries, and is a member of the firm's corporate M&A and securities group. Good morning, Wendy, or good afternoon, Wendy.
Thanks, Tracy. Good afternoon to you too, and thanks everybody for joining us today. So I'm going to kick things off by saying something that might surprise folks. There is simply not a lot of daylight on the issue of antitrust enforcement relating to labor markets and worker mobility between the Biden administration and the second Trump administration, except for one notable exception, which we'll get to later on in this presentation. But also wanted to ask folks, if you have questions, feel free to put them in the chat and we'll try and answer them as we go along. Or if you have experiences that you'd like to share in the chat, please feel free to do so. So we're going to go over a robust agenda today, talking about the interplay of antitrust and labor market enforcement and what is going on with the federal and state enforcement landscape now that we have the Trump administration that's been in power since January. We're also going to look at the state restrictive covenant landscape and talk about risk mitigation at the end. But I wanted to start off by saying that the newly installed chair of the Federal Trade Commission, Andrew Ferguson, and the newly installed head of DOJ's Antitrust Division, Gail Slater, have each made public statements and taken actions strongly suggesting that they will continue to focus their antitrust tools, enforcement tools, on labor market practices, and that they perceive, potentially, if they perceive these practices to be suppressing worker mobility or limiting their opportunity to find new jobs or to find jobs that pay better wages, they won't hesitate to use those tools to go after organizations or entities in a way that the Biden administration did, quite frankly. And so as co-chair of the firm's antitrust practice and an antitrust attorney who's been practicing for 20 years, I have seen a marked increase in the last 5 to 10 years of state and federal enforcers who are either investigating or challenging conduct that they perceive as, again, potentially limiting worker mobility, such as employee non-competes or business-to-business non-solicitation provisions, or even in the mergers and acquisitions realm where a potential acquisition could reduce competition in a particular labor market. Historically, this area has really been left to the states and private plaintiffs prior, to the past 10 years, who were the ones to really challenge these restrictive covenants or conduct under state law. However, DOJ and the FTC have jumped into this arena as of late in various ways and really view it as part and parcel of the purpose of antitrust law. Just as antitrust law requires sellers of goods and services to compete on price and quality, antitrust enforcers view the law as also requiring employers who are buyers of labor to compete, to recruit and retain workers, including by offering better jobs, better wages, and better benefits. And so, the principles of antitrust law, where you're looking at, potential coordination among competitors, as well as a dominant entity's actions that might harm competition, are still applicable to enforcement in the labor market. And the laws that typically apply as they relate to price fixing and market allocation and bid rigging are also being applied by antitrust enforcers at the state and federal levels to go after perceived labor market violations, such as no-poach agreements between competitors, as well as wage fixing between competitors, in addition to using Section 5 of the FTC Act for some novel enforcement of allegedly illegal non-competes. And so you'll see that the antitrust landscape really hasn't changed all that much, and will not likely change all that much going forward. It's just that antitrust enforcers are finding novel and more creative ways to use these tools to benefit workers where they perceive them to be harmed. State antitrust laws generally mirror federal, although, as Tracy will discuss later, there is a growing body of state non-compete laws where they're either proposed or they've been enacted. And these states are enacting really broad bans on employee non-competes, which may fall under the state's authority to go after unfair business practices or may be their own sort of standalone statute. But we're seeing this area of the law develop quite quickly, and it's something to definitely keep an eye on. So as far as enforcement, the usual players appear here: the Federal Trade Commission, which is typically a bipartisan commission comprised of 5 individuals. The chair has changed to Andrew Ferguson, who's a Republican, and the US DOJ is another, obviously, enforcer of antitrust laws and can bring criminal antitrust cases. State AGs also very vigorously enforce antitrust laws. And as I mentioned, many states have enacted or have proposed their own non-compete bans. Private plaintiffs also enforce antitrust law as well, and it is very common for a private civil suit to follow a DOJ investigation that's been publicly announced or an enforcement or settlement action. And the consequences of antitrust violations are quite severe, as you may be aware. They can be prosecuted criminally by DOJ. They can be found to be a felony, subject individuals who may have had a role in a conspiracy. They might face up to 10 years in prison and face up to $1 million in fines. A corporation can also be found to violate antitrust law and can be fined up to $100 million or twice the damage caused, whichever is more likely. There's reputational damage, expensive and lengthy investigations, and of course, follow-on private civil suits. Plaintiffs there can ask for treble damages. So antitrust enforcement under the second Trump administration is starting to come into focus. As I mentioned, the top cop at DOJ for antitrust enforcement, Gail Slater, was confirmed in March. And she was a former policy aide to J.D. Vance. And she was also previously at the FTC as an advisor to Democratic Commissioner Julie Brill. So she is considered somewhat of an institutionalist in terms of her approach to antitrust law, while she has talked about and outlined what she calls America First antitrust policy. The sort of branding is different from the Biden administration. However, the effects are going to likely be the same. She's publicly stated her support for the 2023 merger guidelines, which were issued by the Biden administration's DOJ and FTC. And those merger guidelines are quite novel in that they have several new theories of harm for potential transactions that may violate Section 7 of the Clayton Act, including potential labor market effects of a transaction. And so her support for these merger guidelines means that, she's in effect supporting a potential labor market theory of harm from a proposed transaction. During her confirmation hearing, she said she would vigorously enforce antitrust laws and focus on technology, healthcare, and agriculture. She, in outlining her America First antitrust policy, said that she would target illegal monopoly power that was being used in a way that would harm the interests of consumers and workers, small businesses and innovators. So she seems to be taking the position that she's going to go sort of down the same path as the Biden administration has in terms of labor market enforcement. And part of the path that the Biden administration went down with respect to labor market enforcement, this really started in 2016 when the DOJ and the FTC issued HR guidance. And that guidance stated that DOJ put everyone on notice for the first time that DOJ would not hesitate to criminally prosecute alleged no-poach and wage-fixing agreements. A no-poach agreement is one where there's an agreement between competitors not to hire or not to solicit each other's employees, including cold calling and no direct solicitation. The word naked simply means that there's no other agreement, larger collaboration between the two. The no-poach agreement is the only agreement between the parties. These naked no-poach agreements are considered to be per se or automatically illegal by DOJ, and DOJ will seek to criminally prosecute them where it finds evidence of them. Wage fixing is an agreement to keep wages the same or to agree on wages within a certain range. Could also include an agreement as to benefits, again, between competitors. The between competitors part is a bit tricky when you're thinking about these types of violations. DOJ and the FTC and states are not looking at the labor market definition the same way that you would look at a traditional market definition for a product or service. They're looking at the definition of labor market as typically much broader than a typical product or service labor market that you would think of. And so that's important to keep in mind as well, because what we would think of as competition for labor, they may be viewing in a completely different way. So these types of agreements under the Trump administration were actually being investigated during Trump's first administration. Wage fixing and no poaching. There were several investigations that the head of Trump's DOJ at that time talked about publicly. He didn't name names, but he said these investigations were ongoing and that there were imminent prosecutions. So fast forward to the end of the Trump administration, the first indictment comes down against an individual named Mr. Jindal for alleged wage fixing. And this, signaled the start of DOJ's prosecutions, which during the last part of the Trump administration and the Biden administration, DOJ was 0 to 5 in policing no poach and wage fixing. But I think, given the fact that the Trump 2.0 continues to be focused on this issue, it's worth just running through these cases briefly, even though DOJ lost or pretty much lost every one of these, simply because there are some highlights from these. With Mr. Jindal's operated a physical therapist staffing service. So again, there's a focus of healthcare. You'll see that theme running through all of these cases, except for one. And he was alleged to have conspired with competitors to suppress the wages of PTs and their assistants. The jury ultimately acquitted Mr. Jindal. And you'll see, again, a running theme, healthcare, acquittals, but there are some things to pull from these cases, including the DaVita case, which was focused on DaVita, which is a healthcare company providing for treatment of kidney disease, as well as DaVita's CEO. Now, they were acquitted of alleged conspiracy to not solicit each other's employees with competitors such as surgical care affiliates. But the market here that was alleged was the market for senior level healthcare executives or senior level healthcare employees. And this market, this labor market definition is just very broad and vague. But that is what DOJ went with. They ultimately lost the case. And I think probably in part, there are some technical reasons they lost, but also it would probably be hard for a jury to get their arms around a labor market that's just senior level employees. Ultimately, DOJ also brought a companion case against the competitor to DaVita, surgical care affiliates. But after its loss, the acquittal in DaVita, then DOJ dismissed its case against surgical care affiliates. Again, these were, while these prosecutions were sort of carried forward by the Biden administration, these were investigations that were started under Trump's DOJ. So the other cases that are notable here are the case against Mr. He and his healthcare staffing company, VDA. Mr. He was alleged, along with his company, to have fixed nurses' wages and also allocated the market for nurses. VDA entered into a plea agreement with DOJ and paid a nominal fine. Mr. He entered into a deferred prosecution agreement and agreed to perform community service, after which the antitrust charge against him would be dropped. However, this case is interesting because it highlights that very little conduct was needed by DOJ to substantiate what it believed to be a criminal Sherman Act violation. Although no court and jury ever reached a decision on the merits here, there were these plea agreements which suggested that VDA and Mr. He thought there was significant risk of a guilty verdict. The thing that formed the basis for this particular conspiracy was just 2 communications on a single day. And so this just goes to show you that DOJ was really trying to stretch and allege a conspiracy with probably not as much evidence as it should have. And it also shows you that DOJ also continues to be focused on the healthcare industry. Turning to the Patel case, which is the only non-healthcare case that DOJ brought in the string of prosecutions, it was alleged that there was a hub and spoke conspiracy between a manager at a Raytheon subsidiary, Pratt & Whitney, and executives at 5 engineering staffing companies. The indictment charged that the alleged conspirators agreed not to compete for engineers and other skilled workers on projects for the aerospace firm. Defendants moved for an acquittal, and that was granted by the court, so this case never went to the jury. The court actually stated that no reasonable juror could convict the defendants, and that as a matter of law, the case did not involve a market allocation under the per se rule. And this acquittal may have been because this alleged conspiracy was based on a larger collaboration between Raytheon and the staffing companies. And just on a side note, there have been follow-on class actions to this case as well. Finally, Manahe was the last of DOJ's losing streak, alleged wage fixing and no poach agreement between 4 operators of home healthcare agencies. And this was a conspiracy to suppress wages and restrict hiring of personnel specialists during the COVID-19 crisis. The jury acquitted all 4 defendants, and it appears that the prosecution, again, failed to convince the jury that an agreement was ever actually reached or acted upon by any of the home healthcare operators. But DOJ did not give up. It brought a final case, and we suspect there will be more. This case was against Mr. Lopez. Again, in the healthcare arena, he operated a home healthcare agency in Nevada and allegedly participated in a 3-year conspiracy to fix wages for nurses and LPNs. He also fraudulently failed to disclose criminal antitrust investigation during the sale of his home healthcare agency, which got him a guilty verdict on wire fraud. So this was the first winner for DOJ in April 2025. The jury found on both counts that Mr. Lopez was guilty. A couple of reasons why this case was probably different than the others. Number one, it only alleged wage fixing. And because wage fixing is analogous to price fixing on the buy side, it likely is an easier case to prove and for a jury to wrap its mind around as a criminal violation than an alleged no-poach agreement. Many no-poach or non-solicit agreements between employers are what are called ancillary to a larger collaboration, which makes them more difficult for the government to prove as a per se illegal Sherman Act violation, as long as there is a reasonably necessary business justification to support these ancillary or side agreements. There was also, by all accounts, much stronger evidence in this case, including multiple text messages, statements made that Mr. Lopez made to FBI agents. There was also a leniency applicant that recorded in-person meetings with Mr. Lopez, and there was some victim testimony. So this really underscores that when DOJ takes its time to build its case, it will pay off potentially with a guilty verdict, as it did here. So what does this mean? What does this conviction mean for DOJ's antitrust enforcement in the labor market? DOJ's AAG, Gail Slater, has publicly praised the verdict multiple times and stated that the Antitrust Division will zealously prosecute these types of cases in the future. And so we don't see her backing off of this at all. And we know that, there have also been meetings between her and labor unions regarding priorities in terms of making sure that there's vigorous antitrust enforcement to protect workers. In addition to her other public statements about how she believes the labor market, should promote a free and fair competition for workers. So we know that DOJ is going to potentially continue to go full steam. We haven't had another case come down the pike yet, but we're pretty sure there are investigations that are ongoing in both the no-poach and wage fixing spaces. At the Federal Trade Commission, currently Chair Ferguson and Republican Commissioners Holyoke and Metter are the three that are on a 5-person commission. The 2 Democratic commissioners were fired by President Trump, and they have filed a suit that's wending its way through the courts. FTC Chair Ferguson, much like AAG Gail Slater, has affirmed his support for the 2023 merger guidelines. Again, the guidelines contain this theory of harm relating to labor market effects. The FTC has also launched a review of anti-competitive regulations, including those that could harm workers, that might, prohibit them to be as free and competitive as they wish to be, possibly including looking at certain types of licensure regulations. And we'll just have to wait and see. Comments are due at the end of May. Also, notably, Chair Ferguson announced a labor markets task force that will prioritize investigating and prosecuting anti-competitive conduct in labor markets. And he has promised interagency coordination, and we'll see what happens as a result of this labor markets task force. However, the FTC has paused its pursuit of its appeals of 2 district court decisions that blocked the FTC's rule banning non-competes. So this suggests that this is the one exception to the Biden era initiatives that the new Trump administration does not agree with. And in fact, Chair Ferguson has talked about how he does not believe the FTC has the authority to promulgate such a broad rule. I will also say, notably, DOJ and the FTC at the end of January, or in the middle of January, before Trump administration was inaugurated, DOJ and the FTC issued what are called antitrust guidelines for business activities affecting workers. These effectively replaced the 2016 antitrust guidance. And while Chair Ferguson dissented regarding these guidelines, neither DOJ under Trump nor the FTC have moved to rescind these antitrust guidelines for business activities affecting workers. Again, the guidelines focus on DOJ's, no poach prosecutions, its wage fixing prosecutions, information sharing agreements. It talks about the FTC's commitment to ferret out illegal non-compete agreements, and talks about a whole host of other things that go well beyond the 2016 HR guidance. So I encourage you to take a look at these guidelines and be happy to talk further about them if you'd like. But there are a lot of implications in them if they are not rescinded, potentially for businesses and organizations. And of course, state AGs will continue to vigorously enforce labor markets. They are out there now doing this, and there seems to be no abatement or let up. And in fact, some states are putting their feet on the gas pedals in this regard. One example is California, which recently filed suit against a sanitation service company, alleging it had entered into illegal no-poach / non-solicits with its customers. And that was brought under California's unfair competition law and its non-compete law. There are civil penalties of up to $2,500 per violation. And the allegations include that the company entered into 22 contracts with this language and employed about 6,000 workers under these contracts. So the damages could be substantial. We'll have to see, whether a settlement is entered in this case. At the end of 2024, New York and New Jersey entered a settlement with a company that provided janitorial and maintenance and security services to buildings in the tri-state area. The settlements resulted in the company named Guardian canceling any existing no-poach agreements with its customers. And it also agreed to cooperate with the AGs in any ongoing investigation that may be conducted in the future. This was also a case that was investigated by the FTC. So states also continue to go after no-poach agreements in franchise relationships, and there have been multiple follow-on class actions, including the Burger King case in Illinois, which is now just moving forward to trial. But in terms of the FTC's non-compete rule, as we all know, it was issued in the beginning of January 2023. It was very broadly worded, prohibiting employers nationwide from entering into new non-compete agreements and maintaining existing non-competes with workers, which are generally defined as employees and independent contractors. And right before it announced the rule, the FTC announced 3 enforcement actions against companies who allegedly imposed illegal non-competes against lower wage workers. All 3 companies agreed to settle. There were some dissenting statements from the commissioners, Republican commissioners at the time. However, these actions weren't brought under the new rule. They were brought under the unfair competition prong of Section 5 of the FTC Act. This is the statute on which the FTC's non-compete rule is based. And so, the FTC was making the point that, look, we can bring enforcement actions without this rule against companies who we believe have illegal non-competes in place. In each case, these non-competes were pretty egregious, again, against lower wage workers, and, really just something that was broadly used, and the FTC and companies ultimately settled there. But the FTC, I believe, in the future would not hesitate to bring actions against companies for illegal non-competes on the basis that they violate Section 5 of the FTC Act, regardless of whether there is a non-compete rule in place. And I'm sure you've all seen these slides before if you've attended one of our L&E presentations. These talk about the non-compete rule and how things are defined under the rule, as well as exceptions. And there are certain exceptions for nonprofits, for government entities, for the sales of business, where non-competes are entered into. And we won't spend time talking about this simply because there are 2 pending challenges to the FTC's rule, both of which were on appeal by the FTC. The district courts had enjoined the rule's effective date, essentially kind of putting a pause on the rule. The FTC under the Biden administration appealed, and then the new FTC under Chair Ferguson requested in March a 120-day pause on the appeals. These pauses will expire in July. And so that's when we suspect we'll see something from the FTC, either dropping the appeals and or rescinding the rule, some combination of that. But given Chair Ferguson's statement about the fact that the FTC, he believes the FTC does not have the authority to promulgate this non-compete rule, we don't believe the FTC will continue to pursue these appeals. But please stay tuned. I'm going to turn it over to Tracy now to talk about everything that's going on at the states in terms of restrictive covenants and how this could impact your business or organization.
Thanks, Wendy. So as Wendy stated, there's momentum at the state level to curtail non-competes. And this momentum is not just with states who have in the past been restrictive with respect to non-competes. It is also happening in states who have been more flexible traditionally with respect to non-competes. And the reasons may vary, but certainly one of the primary reasons is the sheer pervasiveness of non-competes and a perception that the harm to the worker is outweighs the harm to the business. Wendy mentioned several types of restricted covenants. I'll just go quickly through these. There are non-disclosure agreements which stop the employees from disclosing proprietary or confidential information of the business. There are employee non-solicitation agreements, such that they stop independent contractors or employees from diverting customers or clients or patients or even suppliers away from the business of the former employer. And then there are non-compete agreements which seek to stop independent contractors or employees from competing within the same industry by imposing, as the former employer, by imposing geographic and temporal restrictions on future employment of the employer. Let's see. And then, of course, there are no-poach agreements, which Wendy mentioned, and those are agreements between two or more organizations not to recruit or hire or otherwise compete for the employees of each other. And this does include those collusive franchise agreements that Wendy was discussing, in which franchisees are prevented from hiring the employees of the franchise of other franchisees or of the franchisor. And many of you may remember the 2018 Jimmy John's case, in which a courier was attempting to find a better job at one of the other Jimmy John franchisees and was unable to do so, and was ultimately discovered that there was a no-poach agreement preventing the franchisees from hiring her. After the Washington State Attorney General became involved, Jimmy John's entered into an agreement voiding and agreeing not to enforce the no-poach agreements not only in Washington but nationwide, and further agreeing not to execute no-poach agreements as part of the franchise agreements in the future. Generally, courts evaluate non-competes based on the reasonableness of the non-compete, and they will consider certain factors. They'll consider whether the non-compete protects a legitimate business interest of the employer. They'll consider whether the restriction is no greater than necessary to protect the legitimate interest of the employer. They'll look at whether the harm imposes or whether the restriction imposes an undue hardship on the employee, whether the restrictions on geographic and duration are reasonable, and whether these restrictions otherwise harm the public. Some courts will also consider whether there is adequate consideration to support the non-compete. But as Wendy said, there are trends which has been within the states to impose additional restrictions outside of these typical factors that courts look at to limit the use and enforceability of non-competes. And we can trace this back a number of years back into 2016 when the Obama administration issued a call to action, asking states to focus on the overuse, or encouraging states rather, to focus on the overuse and the misuse of non-competes. They advocated for bans on non-competes against against public safety workers and public health workers. They advocated for bans against bans on non-competes restricting workers who were in the lower income range. Bans on non-competes against workers that did not have access to confidential information or trade secret information. They suggested bans on workers who had been laid off or who had been terminated without cause. They also urged for greater transparency with respect to non-competes, urging that non-competes be entered into only at the upon the offer of employment or upon a promotion. And the trend has continued through the Biden administration, where we saw a letter issued by 18 state attorneys general in support of the proposed FTC rule. And their letter focused on the unfair use of non-competes and how the pernicious effect on to employees with respect to depressing wages and limiting worker mobility. Now, approximately 9 states have minimal restrictions on non-competes. However, even those states, we're seeing introduction of various legislation to impose further restrictions. A majority of the states have some restrictions on non-competes. 4 states completely ban non-competes in the employment context. Of course, California bans non-competes. That's not a new legal development. They have banned non-competes for quite a long time. But there are circumstances that arise that prompt new legislation, and one of the piece of new legislation that should be of interest to multi-state employers is SB 699. And in SB 699, employers are prohibited from attempting to enforce a contract that is void under California law, even though the contract was signed outside of California and the employment occurred outside of California. Now, this could have been motivated by this legislation could have been motivated by attempts to circumvent California's ban, but it's also been used by employees to try to void otherwise enforceable contracts that were entered into outside of California. One of those cases is Poor versus FTI Consulting. And in that case, an employee was hired by a Maryland corporation. The employee worked in San Francisco. The employee served California clients and was listed on the employer's website as a California employee. And that was in 2013. And by 2019, the employee moved to Nevada to work remotely, still servicing California clients and still listed as a California employee on the website and had access to California offices. In 2020, the employee signed a non-compete with the Maryland Corporation that contained a Maryland choice of law provision. And then the employee sued to void that non-compete subsequently under the law under SB 699. The U.S. District Court for Northern California, however, declined to void that non-compete. They stated that California law does not protect a non-California citizen employed by a non-California business and where the employee was located out of state. According to the court, the contacts with California were insufficient to subvert the choice of law, the Maryland choice of law provision. So certainly there was a lot of significant takeaways from this, but one of them is that when drafting non-competes, employers should be cognizant of their choice of law provisions in the non-competes. Minnesota also has recently banned non-competes, and they took a little bit of a different approach with respect to preventing circumvention of their ban. Their ban prohibits post-employment non-competes with independent contractors and employees at all levels, with respect to employees at all levels, from low-wage earners up through executives. There is an exception for non-competes with respect to the sale of a business or anticipated dissolution of a business. They also exclude non-solicitation agreements and non-disclosure agreements. Those are, they're excluded from the ban. And this law is prospective. With respect to the circumvention, they were concerned that Minnesota employers may attempt to circumvent the ban by using choice of law provisions of states that permitted non-compete agreements. To that end, the law requires that employers use Minnesota law and Minnesota forum in any agreement that is a condition of employment for employees who are either residents or who work in Minnesota primarily. In addition, also in 2023, Minnesota retroactively bans no poach agreements in franchise agreements, which restrict, the solicitation or hiring of employees or independent contractors of other franchisees. And in 2024, Minnesota again enacted a law banning service providers from prohibiting their customers from employing the service provider's employees. This law is retroactive, and it does require service providers to provide notice to their own employees that such agreements are no longer enforceable. There is a narrow provision for computer software developers where it had been intended that the computer software developers would, in the future, be considered for employment at the service provider's customer. I want to speak, just before I go on, I want to speak just briefly about Oklahoma. Oklahoma is also one of the states with a complete ban on non-compete agreements. They do allow solicitation agreements. Employers may restrict employees from directly soliciting established customers, meaning that there has to be a specific customer relationship and the employee must have had direct contact with that customer. A duration of the non-solicitation agreement is limited to 1 to 2 years. Interestingly, Oklahoma also bans any sort of non-compete agreement with respect to physicians on the basis that such a non-compete with respect to physicians is against public policy because it prohibits a physician from practicing medicine. However, recognizing that there is also at stake the employer's business interest, they do allow an agreement between the employer and the physician providing for liquidated damages if the physician departs and continues to practice medicine within a specific geographic scope. Again, this is one way in which another state, Oklahoma in this case, has attempted to balance, the harm to the employee and the public policy of providing access to medical care with the potential loss of revenue and patients by the employer. This is the patchwork. This is a nice slide regarding the different types of, we see, states, the number of states that have a full ban and a number of states with different types of restrictions. And this map has changed, continues to change and evolve, year to year as states impose more restrictions. The types of restrictions that we're seeing states impose, some are states that are imposing income level restrictions to protect low income earners. Again, we see this occurring in states that are not have not necessarily been very restrictive with respect to non-competes. They've been more flexible. However, they're recognizing from a public policy standpoint that certain employees are vulnerable and should be protected from non-competes, especially where there is no protectable interest. So they're imposing income thresholds in an attempt to address that issue. These income thresholds are based on the Consumer Price Index. New Hampshire, one of the lowest income thresholds, is based on the minimum wage, and Washington, D.C.'s income threshold is based on the Consumer Price Index. We are also seeing an increase in state bans on non-competes or state restrictions on non-competes in the healthcare industry. A 2014 study, at that time, they found that at least 45% of physicians were under a non-compete. A number of states have imposed restrictions on non-competes on healthcare providers. Some states have banned completely non-competes with respect to certain occupations within the healthcare profession. For example, Wyoming in 2025 banned non-competes with respect to all physicians. Arkansas, 2025, banned non-competes with respect to physicians and surgeons, as well as osteopathic physicians. Massachusetts bans non-competes with respect to physicians, nurses, social workers, and psychologists. Illinois recently, they banned non-competes between nurse staffing agency and nurses and certified nursing assistants under certain situations. Effective on January 2025, Illinois enacted another law which bans non-competes and non-solicitation agreements with respect to mental health services provided to veterans and first responders by licensed mental health professionals. So certainly there have been a lot. I can tell you in 2025, there have been numerous bills introduced in state legislatures proposing restrictions based on both income levels and especially with respect to healthcare provider bans. So what should employers be considering going forward? Well, review your state non-compete laws in states where you have employees, in states where you're located. Make sure they comply with the latest laws and restrictions. Make sure that any restrictions are narrowly tailored and are no greater than necessary to protect the employer's interest. New employees should be provided non-competes at the beginning of employment. And keep in mind that public policy concerns around different industries and different levels of wage earners, and when you are including non-competes as part of the employment agreement. And then once of course you have vetted your non-competes and you're in compliance, then enforce the valid non-competes as necessary. Wendy?
Thanks, Tracy. There's several risk mitigation strategies that you could employ, and you probably already are employing most of these. But ensuring that you are reviewing your procedures, ensuring that you're training the relevant personnel, not only to ensure compliance with antitrust law, but also helping folks understand the risk around communications with a competitor, in particular regarding anything relating to pricing, of course, but also wages and compensation, along with recruiting and hiring practices. Even if you're part of a trade association and they're conducting a third-party survey regarding fees or potential compensation benchmarking, that could put you at risk. The DOJ and the FTC both have withdrawn previous safe harbors for information sharing. And so if you're still planning on engaging in the surveys, compensation benchmarking surveys, please consult with an attorney before you do that. There is some risk around that particular issue. And finally, review any existing non-competes, as Tracy said, audit your organization, and train as much as you can, the relevant employees who may be involved in recruiting, hiring, compensation, et cetera. We can't emphasize enough that as long as you are making and taking really good proactive steps, that will be worth a pound of cure later on. And DOJ, the FTC, state AGs, they're all quite active in this space. So we really do encourage you to be proactive about it, and not wait for that phone call, that email from DOJ, saying they're sending you a litigation hold notice because you're part of an investigation they're conducting. So, we welcome any questions you all may have, but I'm not seeing any in the chat here. I don't know about you, Tracy, if you're seeing any.
There is one. The question is the exemption for nonprofits, does it apply to all restricted covenants or just non-competes?
So the exemption for nonprofits that I mentioned was in connection with the FTC's non-compete rule. If that rule ends up, moving forward and becoming a rule that's enforced by the FTC, there would be an exemption under that rule for nonprofits, since Section 5, on which the non-compete rule is based, historically has not covered certain types of nonprofits, and that includes healthcare nonprofits. However, there are a select few nonprofits, like I think 501c6s, that do fall within the jurisdiction of the FTC under Section 5 of the FTC Act. So it depends on what kind of nonprofit you are, but great question. All right, any others?
I'm not seeing any.
Okay. Well, thank you everyone for joining us today. We really hope this was helpful. It was a high-level overview. We're still collecting data points as to the direction that the Trump administration is going to go, but all indications point in the direction of continuing to focus on labor market enforcement, as are the states. They are going to continue to focus on this issue as well. It's a very populist issue. It crosses party lines, and we don't expect to see a let-up, except potentially that the FTC non-compete rule will go away at some point, based on FTC Chair Ferguson's prior statements. But again, when we receive definitive news of that, we will communicate that to everyone. But in the meantime, we hope this has been helpful for you. As a reminder, this program was approved for legal education hours. So to report your hours, please click on the continuing education sign-in button at the top of the screen, and a certificate of attendance will be emailed to you, including course numbers, tomorrow, along with a recording so you can watch and share. And also, please be sure to complete our survey. And we love feedback in any form so that we can plan future programs that are of interest to you all, as well as to your businesses. So this concludes our webinar. Thank you very much and have a great day.